deal first with the reply on my application. The first point is that, contrary to what my learned friend Mr. Brindle suggested, allowing our evidence in would, we submit, be consistent with what the court envisaged in the October hearing and in no way inconsistent with it. There's nothing to suggest that any opportunity was extremely limited. We obviously had to comply with the provisions of paragraph 8 of my Lord's order, and we sought to do so. The second point, my learned friend says, well, in relation to CBK, what is the justification? But the real question I would respectfully submit is what is the prejudice in letting it in? And in my submission, it is not relevant prejudice for my learned friend to rely on the fact that they were hoping for a windfall, and that if my Lord lets in the application, lets in the evidence, they won't get that windfall. Well, the next point I wanted to make was that both Mr. Brindle and Mr. Black have made various submissions about the pleading. Now, these are submissions that can be made at the quantum hearing, and indeed I understood my learned friend Mr. Brindle to be conceding that point when my Lord asked him about what is his objections in relation to the ABK position and the interest certificate. But Mr. Black rather got the impression wasn't conceding at that point. And in my submission, the pleading objections both can be made at the quantum hearing if they want to, but in any event are bad objections. And we have pleaded that this is pleaded extensively in the pleading, but this is a no transaction case. We, in my submission, were never to be held at this stage to the old form of Appendix B of our particulars of claim, because that had already been superseded by the time of a trial, and we've been proceeding on the figures as they were presented at trial for some time now. And the claims that we want to make and the evidence we want to put in is well within the order and paragraphs 3b and 5b of the order, and it really is, in my submission, a technical and unmeritorious objection to run a pleading point at this late stage. There was then an unnecessary debate in my submission about the accountant's reports and whether or not they are expert evidence. Learned friend Mr. Brindle attempted to say that these are expert evidence properly so called, but it was clear from his own description of what they deal with, and clear from the passages he took my Lord to, that in fact they're not expert evidence, and that the position is exactly as my Lord summarised it, and indeed as I have described it. It is an exercise that the court and the parties will have to do, the exercise that the accountants have undertaken. The accountants have given a useful presentation of it, but that has no special status. And so it's not, my Lord will never be resolving disputed opinion evidence. And so for that reason, there's no purpose in my learned friend's attempt to exclude the accountant's reports. We would, in my submission, be entitled to rely on them and cut and paste them, if we liked, in our submissions. For an example of that, my Lord saw in the Griffin supplemental report, which was at tab 14, at page 1609 of the bundle, of bundle 6, that actually sets out the Griffin presentation of our ABK claim. Now, as I explained in my opening, the relevant liability is one that ABK, that Griffins have provided a calculation of, but there's no magic in what Griffins have done, and we, if it were necessary, could provide our own calculation, but all we would be doing is cutting and pasting and reproducing exactly the reasoning that Griffins have provided.
Mr. Hill, can you just make it clear to me how it is that you say you get RAK5, which is tab 14, and which includes the Griffin addendum report of the 7th of January 2015. How do you say you get that for the court?
Yes, this is our reply evidence. So the court ordered us to serve evidence in reply in by the then date was 1st of January, but there were consequential slippages agreed between the parties, so that date moved to 7th of January. And this is our reply evidence served on 7th of January.
So what's it a reply to?
We replied to Jabala 3 and the material put in by the defendants on this point, which they of course include the Jabala 3 exhibits 2 KPMG reports. So what Griffins do in their supplemental report is answer the KPMG reports, and that comes in under our Karafi 5, which exhibits Griffin's supplemental report in answer to the KPMG report. And there's no, on much of these heads, there's no issue about that, because much of what Griffins do in their supplemental report.
So if that analysis is correct, what has this got to do with your application of the 20th of November?
Well, we do still rely on, want to adduce the material. We obviously, in relation to ABK, we want to adduce the underlying certificate. We've covered that. In relation to CBK, we want to introduce the underlying documentation. Though that's documentation that's exhibited to Mr. Al-Kharafi's fifth witness statement. It's also appended to the Grant Thornton report, which is itself exhibited to the fifth witness statement.
I'm afraid I don't understand that. If you filed 2 witness statements of Mr. Al-Shamsi on the 20th of November, right?
Oh, yes.
In fact, as the defendants point out, you did that disregarding the terms of my order of October, because what you were required to do was to file a witness statement relating to post-trial events, which was purportedly the first Al-Shamsi witness statement, and you were supposed to make an application and attach draft witness statements in relation to the evidence which was pre-trial evidence.
Oh, yes.
Now, the reason for that form of order was that the defendants would not have to respond to your draft evidence because it wasn't there as evidence until you'd obtained permission.
Yes.
I thought that would be likely to happen on the papers quite quickly, and indeed your application of the 20th of November was for a paper hearing. That got swallowed up in the defendant's application to strike out all your evidence. Now, Shamsi 2 does not, in terms, refer to RAK 55.
No, because that came off.
Because RAK 5 wasn't, RAK 5 wasn't around in the sense that it wasn't an exhibit to anything that was then in evidence. So So, looking at Shamsi 2, it doesn't seek to rely on RAK5. The way you seek to get RAK5 in, as I understand it, is you say, well, this is an exhibit to an affidavit in response to the defendant's reply to Shamsi 1, isn't it?
My Lord, yes. We only had one set of evidence from the defendants in December.
Yeah.
It appears on it, although it obviously is evidence in support of their application to strike out, it appears to be responsive evidence as well. There's no other responsive evidence. So we replied to it in accordance with the order.
Well, the order certainly didn't require you to reply to anything raised by their application to strike out.
My Lord, no, but we
was
put...
to reply to evidence which they were... You were allowed to put in evidence relating to post-trial events. And remind me if I'm wrong, but I think your evidence in relation to post-trial events was Shamsi 1, wasn't it?
Lord, Shamsi 1, but although Shamsi 1, it's right to say covered pre-trial events as 2, and that's why Shamsi 2 attempted to pick those bits out of Shamsi 1. So we had one presentation in Shamsi 1, and then Shamsi 2 was intended to pick out the bits which needed
nothing in
application.
Shamsi 1 which related to pre-trial events had any business to be there.
Well, my Lord, the way we did it, I certainly take my Lord's point. The way we
I
thought...
appreciate that you thought you had a better way of doing it than the court had asked you to deal with it. That you're not alone in that view.
Well, I certainly
And
apologise.
that's what happened. The court told you to do one thing, and you decided you knew better, and you did something else. But the fact that you chose to do something else doesn't alter the structure. The structure is that you were allowed to put in evidence relating to post-trial events, and so much of Shamsi 1 as deals with that was perfectly legitimate. So much of Shamsi 1 as dealt with pre-trial events was not admissible under my order. In order to make it admissible, you had to apply for permission to use it. The right way to do that was to have it in a draft, and then if you got permission, you filed the draft, and they would then have to respond. You filed the evidence in the draft, and they would have to respond to that.
Yes.
But their response actually is a response to the evidence that you were entitled to put in.
Well, I'm not sure.
If you want to rely on RAK5, I think what you have to say is that this is a response to the evidence which they chose to put in. And it has to be judged on that basis. In other words, what have they read? Is it truly a response to the evidence that they put in, or is it some new evidence which isn't in the least responsive, but is bolted on to the evidence you had the first time? Because if it is properly described in that way, that it's actually new evidence which you're trying to introduce by way of a responsive affidavit, it's illegitimate, and that's not what responsive evidence is about. And so, if you can't get it in as responsive evidence to the evidence which they chose to serve on you, how are you going to rely on it? You can't rely on it because you get it in under Shamsi 2, because Shamsi 2 doesn't refer to it.
Just to make sure, there's some confusion here, my Lord Junior. Just to make sure I've entirely got my Lord's point. My Lord it's common ground that we were entitled to put in evidence so far as it related to post-trial events, and we were entitled to reply on that, which is what a lot of what, which is what most of what we see in RAK5. The point I'm dealing with my lord is how does that relate to our application, and in particular the CBK losses. And what we have done is the defendant's evidence does attack the quality of our first round, as it were, which is the subject of our application. They did attack the quality of that evidence in their evidence in December. We responded to that by essentially dealing with their complaints and putting in further material. So, for instance, in relation to CBK, there was a complaint in December, and part of their reasons for objecting to our application was that we hadn't produced the underlying bank statements. That's listed. That's one of the objections listed in the KPMG first report filed by the defendants. So what we did in January was answer that by putting in material that met their complaints. Now, I do accept, my lord, there could be a criticism of that to say, well, if we're going to do that, if we hadn't done that by November, it's too late. But in my submission, it is a proportionate and reasonable way to approach this, to see what their criticisms are, and if their criticisms are ones that require further evidence, to put that evidence in our reply evidence in January, which is what we did. So what Mr. Karafi's evidence in January does is two things. One, it is, on any view, legitimate reply evidence on the post-trial events, but also it introduces material that plugs the gaps that were the subject of the defendant's complaints in December on the pre-trial evidence. And I do accept that there is, of course, it could be said, any gap plugging of that sort, it's too late and it should have happened in November. But in my submission, it's an acceptable way to have done it, and one I certainly invite my lord not to exclude, for instance, the CBK bank statements on the basis they came in January and not in November.
Well, I just want to understand how it gets in under your application of the 20th of November.
Yes. Well,
I mean, there's a quite different point, if I may say so,
yes,
which is whether it should be struck out under their application.
yes.
But how do you seek to get it in?
Well, my lord, my application of 20th of November is one that I accepted it this morning, needs to be expanded to include, the points which I have relied on in my... I've identified the evidence we rely on in our table. So, for instance, the point I just made, one can look at item D on page 6, and my lord will see the evidential references I've just given to Al-Kharafi are there. And so it is in my submission a question of treating my application as expanded to include the further material that goes to that claim and that was put in January.
That's really asking me to give you leave to amend your application of the 20th of November, to add to it anything you thought of subsequently. Why should you have that application?
Well, my lord, it's...
I mean, Mr. Brendel has a point which he makes with force, that I mustn't allow this to spiral out of control. Well, that's what I'm seeking to prevent. A regime which says you can tack on to your application of November anything you think of subsequently seems to me to have all the hallmarks of spiraling out of control.
Well, my lord, just to test that, in relation to post-trial evidence, there is a natural process of us putting in evidence, them responding to it, and then us having to react to their response, which might take the form of adding further evidence. It's quite difficult for us on our side of the court if that natural process isn't one that can take place in relation to these pre-trial losses, and we only get one go, and we're not entitled to respond to criticisms and gaps pointed out by the other side.
If I may say so, it's also unsatisfactory. If the court directs you to do one thing, you choose to ignore that and do something else, and then by doing something other than what the court told you to do, you hijack the process.
Well, I certainly apologise for the fact this process has been complicated.
You don't have to apologise for it, I just simply have to react to it.
Yes.
But I just want you to appreciate that that's what I think that has happened.
Yes. No, I take that, but what I do submit is that where the further material we put in is a reaction to their evidence and response.
You don't have to apologise for the fact that I don't turn out to be quite as stupid as your side thinks I am.
Well, there's obviously no remote suggestion of that in this case. What has happened is, in relation to both categories of evidence, the pre-trial and post-trial, we have responded to them by adducing further evidence. And in my submission, that's a fairly natural way for evidence to progress when you're trying to litigate an issue. And it would make things particularly difficult for us if evidence that we put in response to them once they had identified gaps is because it's pre-trial, is something we're not allowed to adduce because it's post-date of the November deadline, whereas we are allowed to adduce it in relation to post-trial evidence. It just would have made that evidential task fairly impossible if we weren't able to react to the other side's points. And so that's the reason that material has come in January under Mr. Karafi's witness statement.
I think the answer to the point I'm putting to you is that if you are able to rely on RAK5 at all, it has to be because you can demonstrate that it is in fact properly to be regarded as responsive to some evidence which they put in relation to Shamsi 1.
Well, it is in the sense that Shamsi 1 makes the same points, for instance, in relation to CBK lending. Jabala 3 adduces the KPMG first report, and that identifies the gaps that we've been plugging. And in fact, Jabala 3 states...
If they choose to react to Shamsi 1 by putting in KPMG in their reply evidence, you may be able to persuade the court that RAK5 is a proper response to that. But that's got nothing to do with your application of the 20th of November.
Well, I can certainly see that's one way of looking at it, but I would also invite my Lord to treat our application of 20th of November as extending to the evidence in reply on the same points.
Well, you're inviting me to allow the process to spiral out of control, and I'm not very attracted by that invitation.
Well, my Lord, it's a very limited. If it's a sparring at all, it's a very limited sparring, because really what we are doing is responding and putting in further material in response on an issue we've identified where they say you can't prove that issue without X, Y, and Z, and we've got in and gone on and put in the evidence on X, Y, and Z.
Well, there we are.
That's all I can say about that, my Lord. We do submit that, back on the point I was on, in terms of the accountant's reports, there wouldn't be any purpose in excluding reports per se when we could cut and paste them into our submissions. And we also submit that we shouldn't be permitted, shouldn't be excluded from relying on the underlying documents which the accountants have used for their arithmetic, some of which, as I've said, in relation to CBK in particular, do come in under the guise of Karafi's fifth witness statement, which is in January. In relation to CBK, it was submitted that the fact that some of the lending was refinanced was in some way relevant to the questions of liability on which the claimants might have been cross-examined, having regard to their sophistication. This is, in my submission, a non-point, in that the fact that there was a refinancing would have added nothing to the other material before the court showing the level of the claimant's financial sophistication. The court already had quite a lot of material showing, for instance, Mr. Kharafi's various business investments, and the fact of the refinancing of ABK lending wouldn't have added a jot. There was then the point taken about how the CBK position would be proved, and as I submitted, we would do it through Mr. Kharafi, obviously who's already given evidence. And so whether one did it formally through Mr. Al-Shamsi confirming that he relied on Mr. Al-Kharafi, and then us tendering Mr. Al-Kharafi in the underlying documents, or whether one did it the way I respectfully submit, which is one allows Mr. Al-Kharafi's evidence in the underlying documents is obviously a matter for my lord. Well, that's what I was going to say about my application. There's then the points to be made on their application. If I could start with category E, which is the real estate financing, the real estate undervalue loss. Now, the evidence on that is in two witness statements from Mr. Al-Kharafi, his 5th and 6th at tabs 9 and 16, and those both made it clear.
Sorry, can I just have a look at that? 5th?
5th at tab 9, which we... sorry, I've got the wrong reference. Sorry, I've got two wrong. The 5th is at tab 13.
This is not evidence which you filed in accordance with the order, because this is responsive evidence, and the complaint is that it's to try to introduce a claim relating to sale at an undervalue of the tower is hardly responding to anything that they're saying, isn't it?
No, well, I'm not sure that is the complaint, because there's no issue. There shouldn't be any issue on this one, because the first reference I should have given you was tab 9, which is his 4th witness statement, which explains it.
That bundle?
That's at.
You won't know.
Yeah, I do. I've been given it. It's tab bundle 18. No, sorry, it's bundle 3. Bundle 3.
Bundle 3. This is Kharafi 4. Yes, and where do we get it in Kharafi 4? Well, it's really what...
So, my lord, so that's the 4th witness statement.
What all Kharafi 4 is about.
Correct, exactly. And that came in November. So that was in accordance with the order, which, because of course this isn't the subject of our application, because this is just ordinary post-trial events. And we then got their...
the post-trial event is the sale of the tower in June 2014.
Well, yes, I'm going to come to that point in a minute, and the learned friend's suggestion that it's somehow a pre-trial event. But then we have the... Mr. Kharafi then comes back to it in his 5th witness statement served in reply in January, and that's at tab 15.
Well, you say he comes back to it. Is he responding to something they've said about it?
This is another area where their criticisms are in Ms. Jabala's evidence, her 3rd witness statement, and I believe in one of the first, I think, of the KPMG reports. So it's another area where they have criticised the quality and the content of Mr. Karafi's evidence on this point. Yeah, where they criticised the quality and content of the evidence on this point, and we have come back with our further evidence. And there is a certain amount of gap plugging there, but this, in my submission, falls into a different category from the points we've just been dealing with, which is on our application, because of course there's a question of whether we were allowed to plug gaps on our application if it's pre-trial losses. But this is just the ordinary process of post-trial losses. We put in our case, our evidence, they've criticised it, we've put in further evidence in reply, and in my submission there can be no technical objection.
Where is the reference in Karafi 5 to the town?
So it's Karafi 6, tab 16.
Correct. Not Karafi 5.
No, I apologise.
Karafi 6.
Yeah.
Why do we have two affidavits from Mr. Karafi of the same date? Presumably because the sixth one, they both say, I make this statement in reply to the evidence served on behalf of the defendants. Why do we have two of them?
Well, because what happens is the first one deals with claims A to C, and the second one deals with claims D and E. And the explanation is it's at the end of the fifth witness statement. The explanation is the end of the fifth witness statement, which is at tab 13 of paragraph 11. So he explains that in paragraph 11 there, at page 1598 of the bundle, that D to E will be dealt with in a separate witness statement. So he deals with D and E in his separate witness statement, which is the sixth witness statement.
So then we go to
Then go to tab 16.
1838.
Which he then explains at the beginning of that is supplemental to the one he's just sworn, and which is dealing with D to E.
What is this responding to? Seems to be telling the story all over again.
Well, it is repetitious, I accept that. Both these witness statements are responsive, are evidence in reply. And as Mr. Karafi makes clear at the first, in paragraph 1 of his witness statement, his fifth witness statement at tab 13. So, no, but I certainly accept that it's repetitious.
Well, it's repetitious of Karafi 4, isn't it?
Yes.
What's the point of having something in response which simply repeats what's already been said the first time?
Well, what he does do is develop the calculation of paragraph 27.
That's argument, isn't it?
Well, it could be said that's argument, yes.
Well, it certainly isn't evidence.
Well, Lord, in my submission, it wouldn't be right to try to conduct a sort of cherry-picking exercise to see if there's any material which material is repetitious, which isn't. I mean, the intention was to actually assist everyone by putting it all together in one place. So with any luck, when we get to the quantum hearing, we need only concern ourselves with the sixth witness statement, because it subsumes what's said in the fourth. With any luck, we'll be able to do that, and we won't have to look at two witness statements. But I certainly accept that it's quite widely repetitious.
Well, can I just explain that it doesn't actually assist the court to say something twice, because the court then has to ask itself whether you're saying something different the second time from what you said the first time. If you're just simply saying the same thing twice, it isn't of assistance, it's just a nuisance.
Oh, Lord, I think I'll be corrected from those around me, but I think the main difference is the introduction of the calculation. But this is, in my submission, of course we accept criticism that one shouldn't repeat oneself, but subject to that criticism, this is evidence in reply, and it's evidence that we were entitled to put in, having seen objections or criticisms from the other side in December. There was a there was a timetabled step for evidence in reply, and this is what we've done, and we perhaps shouldn't have repeated ourselves as much as we had. We could have done it with a series of cross-references, which perhaps would have been more useful. So in relation to this category, we do say that this loss arises from a post-trial event, because it arises from the undervalue and the resulting shortfall on the guarantee. And as my Lord observed in opening, we couldn't have claimed for this loss at trial. There might never have been an undervalue, there might never have been a claim. It's then said by Mr. Brindle that this will lead to an unjustified extension of the process, but it's not unjustified, because this is a head of loss that falls within the order and was contemplated at the hearing in October, and it arose following the trial. There is then the pleading point taken again, which in my submission is a bad one. Of course it's open to my learned friends to take these points at the quantum hearing, but it's certainly not a strikeout point. This again is a loss within the order, and it's within our pleading, which pleads in numerous places the fact that we put our damages on the basis of a nil transaction case. And what's more, this particular claim was expressly contemplated in October. Directions were made, and there was no provision for some sort of further pleading process. Mr. Brindle then moved on to category C4, which is at page 5 of my table, and this is a loss, a head of loss which is introduced in the Griffin supplemental report attached to Mr. Al-Kharafi's sixth witness statement. Now, it's right to say there's no application to strike that out, but it's also right to say one shouldn't strike that out, because this is a head of loss which simply relies on a calculation. My learned friend himself observes that there's no underlying evidence put in on this, and that's right, and therefore we will stand or fall on what we can make by way of the calculation at the quantum hearing. So it's not a point which matters, not a point which really arises for today. What we will submit is that all Griffins have done is done a calculation which we could equally do ourselves in our submissions. The point that's made against me is that our case in some way relies on the proposition the claimants took out borrowing to fund the cash introduced, and that underlies the claim. But that's not a correct point, because we would be making this claim irrespective of whether the claimants had actually taken out borrowing to fund the losses, because we would just say this is an inherent cost of capital which the court can calculate and apportion, and one doesn't need any additional evidence to do so. Well, that's what we will be submitting in the quantum hearing, and of course the learned friend can make submissions about that as he likes, and it's a matter for the next hearing.
Well, if you don't need any additional evidence to do so, then we won't object to having a bit of
this hearing to plug that gap, then I've no doubt my learned friend will object vigorously.
I don't want you to be encouraged towards thinking that you're likely to get permission to put any more evidence in for the trial.
We are stuck with the evidence we've got. We've accepted already that supplemental Griffin's report is not itself evidence, rather as opposed to a calculation, and so we are stuck with the state of the evidence as it is, absent some future application by us, and I'm certainly not saying I'm going to put one in. My Lord, there's then Mr. Black's points, and he made 2 points really. The first one was essentially the same timing and pleading point, which he appeared to be even making it in relation to the ABK losses, which I understood my learned friend Mr. Brindle to be conceding for the purpose of today. And as I said, we always proceeded on the basis that these losses would be on the agenda and no requirement to plead, and they're covered by the order, and it's a point that my learned friend Mr. Black can make at the hearing. Secondly, my learned friend repeated in my submission, bad point made by my learned friend Mr. Brindle in relation to claim E, and whether it's a post-trial or a pre-trial loss, because of course it's an undervalued loss that relates to post-trial events. Unless I can assist my Lord further.
Thank you. Mr. Brindle,
Well, I think I can reply briefly, purely obviously on my application. With respect, the London hasn't really met the main gravamen of our point. Can I take you back to the first witness statement of Mr. Al-Shamshi at tab 6, which is in bundle 1. And see, this is the evidence that we are seeking to strike out, essentially. I'm not going to say anything more about Grant Thornton or anything like that. This is the essence of it. They serve.
Can I just make sure I've got that?
Yes. So I'm going to ask you to look and remind yourself of it.
Tab 6.
Tab 6 of bundle 1.
This is Al-Shamsi.
Al-Shamsi 1. So this is served purportedly without the need for any permission at all. This is not something they're asking for any leave to put in. This is Mr. Al-Shamsi saying, I am entitled, under the court's existing order, to put in this evidence. And that's what I'm saying he goes wrong. So what he does then, in this witness statement, he starts off, straightforwardly enough, in paragraphs 1 through to 10, which I haven't got anything to say about. So he deals with other fees and interest charged by Bank Saracen, and he deals with other fees and interest charged by ABK up to December 2009. But he then, and this is the objection, paragraph 11 and following, he comes up with what he himself describes as other losses. Threefold. One loss is relating to the Kuwaiti property, 2 losses charged by CBK, and 3 interest foregone.
Is it only that part of it that you want to strike?
Those 3, yes.
Well, everything that comes after that heading.
Yes. Yes.
So that's 11 to the end.
Yes.
I suppose you go.
Yes, my Lord, because I'm not concerned with what he said in paragraphs 4 through to 10. But I am sorry, so the answer to your Lordship's question is yes. He actually quantifies them in 15 to 18, but the description of what these are is in 12 to 14. And one can see that these are entirely new matters. They are indeed other losses. And we'll see in a moment how far outside your Lordship's order all of this is when I take you back to your order. But as your Lordship is now familiar with the essential nature of these, it's the RAFCO claim, the undervalue on the sale of the property, the CBK matter, the fact that there'd been this settlement of liabilities had never previously been mentioned, so it's coming in for the first time, and then this point, smaller point about interest foregone. Now these are all other losses, says Mr. Al-Shamji, but, says Mr. Al-Shamji, I can put in all this evidence without leave of the court. And that is fundamentally wrong. If I take your Lordship back to your order and your statement of reasons in tab 36, bundle 12, my Lord. Could I ask you to perhaps keep Mr. Al-Shamji 1 open just to compare those paragraphs with paragraph 9 of your Lordship's statement of reasons. Because we're not on here, we're not on an application by the learned friend to be allowed to do anything. We're on what he's entitled to do. What your Lordship said in paragraph 9, just to remind you, I'm sorry we've been there before, having said this force in the defendant's submission, you then say the evidence on which the claimants are entitled to rely for the purposes of assessing the quantum of their claims is the evidence that was before the court at the trial, subject to the possibility that the quantification, and then these words, of those claims may be affected by a result of post-trial events. So for that reason, I think it's right to restrict the evidence which the claimants may adduce in support of their contentions on the quantum determination to post-trial matters. And then, of course, you leave open the possibility that they make an application. But that part we're not concerned with on my application, so you can leave that part for the moment. What your Lordship is saying is the evidence they're entitled to put in is assessing the quantum of the claims in the evidence that was before the court, and that those claims may have to be updated to deal with post-trial events. My Lord, on no view of what your Lordship said there, can it be said in my respectful submission that Mr. Al-Shamsi's first witness statement, in the paragraphs I object to, can fall within that rubric? The most that could be said is it might have formed the basis for an application, as has taken place with my learned friend's other points, which he's dealt with on his application. But these are, as Mr. Al-Shamsi himself says, other losses. They are not an updating of losses which were claimed at trial, they're wholly new. And that's the simple point that the learned friend simply hasn't come to grips with. His side have taken the position, a risky one and a false one, of thinking they can have this in paragraph 11, Mr. Al-Shamsi, thinking they can put that before the court without permission, but it doesn't work because it's outside the terms of your Lordship's suggested order.
Sorry,
that is my simple point. I'm sorry, my learned friend, just allow me to finish, and then you don't see why he should be allowed actually to have it.
Well, because it's a new point, which is I want to be able to respond to. I don't even understand it.
It's not a new point at
If
all.
you think there's a new point, you can ask for permission to address it when Mr. Brindle has finished.
Very well.
Interrupting him isn't the right way.
Very well. Of course, I don't object to that.
I will now interrupt you, Mr. Brindle, in order to say that I think, this is really for clarification, when I was talking about the quantum of their claims in 9 and the possibility that quantification of those claims may be affected, I think I'm referring to the claims which are set out in paragraph 2 by reference to paragraph 428 of my earlier judgment.
Yes, but your Lordship is saying the quantification of those claims may be affected by post.
Yes, I think that's what I mean by claims, I think.
Yes. Lord, looking at those, how can it be said that it's not a question of whether or not the loss, let's take the Raffico point, it's not a question of whether that loss actually accrued after the trial. It's a question of whether or not the post-trial event, namely in this case the quantum D sale, was something which affected the quantification of something that was already before the court. It can't be. It's a wholly new matter, my lord. It's a question of, it depends entirely on something new. So the question of Rafco, the whole story is a new story, and on no basis do I submit that can be the case. Even less with CBK, where it's only because of some post-trial settlement which is put forward, it was never before the court. That can't be said there, that there's something happening post-trial which affects the quantification of a claim in respect of which there was evidence before the court at the trial. So whether or not this is a new point, I very much doubt that it is. It's the point that we may not have made particularly orally, it's certainly made in writing. It's absolutely fundamental to the whole matter. What my learned friend should have done in relation to these three items was to have come to the court and said, can I please have leave to introduce these? not simply slip them in, hope to get away with it, find themselves met with a strikeout, still not apply either to amend the pleadings or for permission, and just hope to get away with it. Well, that is my simple point on the reply.
Well, there is a new point. The suggestion is made that paragraph 12 of Mr. Al-Shamsi's evidence, insofar as it relates to RAFCO, let's leave aside CBK, because I of course accept I have to make an application on that. The suggestion is made in relation to RAFCO, that's outside the terms of my Lord's order. Then the opposite is the case. This is part of a losses associated with ABK lending, but is expressly within the terms of the order at 3B and 5B. This is a loss that was expressly discussed and contemplated at the hearing that we had. I can give my Lord the reference, I need to take it up now, but it's in tab 48 in bundle 14, at page 4244, where I raised the point that there were these losses on foreclosure, and it's in that light that the order was made in the terms that it was. And I really don't understand the suggestion that we are now in some way outside the terms of the order when we bring evidence on the very point that we said we'd be bringing evidence on.
Right, if you've both finished the submissions you want to make on the two applications that are in front of you.
Oh, yes. Yes, more.
Well, as I said, I will consider my ruling overnight and give oral ruling tomorrow afternoon, probably not before 3 o'clock. The parties large will be advised of the time, but
Okay, well, my Lord,
not before 3 o'clock.
is my Lord able to indicate whether you may go along with the suggestion that we have 24 hours to put in a written submission rather than have anyone be ready to argue things tomorrow afternoon?
You can have 24 hours to put in submissions as to any particular directions you want in the order, but I'm not inviting submissions which seek to go behind the ruling that I reach. There's another place to do that, and it's not here.
And similarly costs, insofar as my Lord hasn't already disposed of.
If as a result of the ruling, either side wants a particular direction about filing documents or calling witnesses or putting in further argument, then that can go into the order you can make it. You mentioned, Mr. Hill, that there was possibility in the wings of an application for some form of post-judgment freezing order against the first defendant.
There is, my Lord.
I mention it because, first of all, is that at all likely to be made tomorrow?
It's possible, but Lord, where we've arrived at is my learned friend is going to write to us, and apparently we're going to get that tomorrow. It's possible that that will satisfy us, but if it doesn't, we may be having to come quickly to court for some form of post-judgment moreover.
Well, if you do, it will have to be after I've given this ruling, so it'll have to be tomorrow afternoon.
Lord, yes.
And you'll need to make arrangements for
Lord,
that.
yes.
If it doesn't happen tomorrow, the next time that I should be here is towards the end of this month. I'm in Dubai on the 25th of January through until the 27th, I think. There's something else that's possible. Something else might pop in the 28th, 29th May. Is that definite? Yeah. Anyway, you might get a slot towards the end of that week, 27th, 28th, 29th. It's a possible slot, but it's
Well, my learned friends will...
After that, the next time I'm here is on the 15th.
I'm grateful. Well, obviously,
15th, 16th February.
if we're going to make the application, it's obviously relatively urgent. So if it's not tomorrow, it will be on the 20th, in that slot, if we can make it in 25th to 29th.
Well, I just mentioned it so you know what the availability is.
And my learned friends will also have heard what my Lord said, and it's in their interest, in their letter they write us tomorrow, to give us sufficient reassurance that we don't need to apply tomorrow. So if we're going to apply, it can be done on the 25th. So much depends on how much comfort they can give us.
If it has to be made after tomorrow but before the 25th, then if it's short, I can hear it by video from London.
I'm grateful.
But I set my face at the moment against a situation where all council and I are all on a video from London. Because I think, first of all, the technology probably couldn't cope with that. And secondly, it is a Dubai court, and I think it's rather unsatisfactory if it's being said up between three silks and a judge in London.
I think it may even be unconstitutional, but I wouldn't necessarily...
There are all sorts of problems, I think. So, if it is going to be made, you better try and make it tomorrow, or you can try and get a slot at the end of the month.
No, we're grateful.
Mr. Black, I'm sorry, is there anything else you want to say? I haven't called on you, I think, in response to... Thank you. May I just say, Mr. Brindle, that I fully understand why you're not able to be in Dubai today, and I just express my hope that all goes as well as you can hope for. Well, as I said, I'll give a ruling in this matter tomorrow afternoon. The best indication I can give is that it will not be before 3 o'clock. If those instructing you are in contact with the registry around about lunchtime, you